Viewers, welcome back to the PI show. We're discussing that famous case of Donahue and Stevenson. This is what they were contending with back in 1928, and the case that actually went to the House of Lords in 1932. It was a bottle that looked a bit like this. Anyway, Beth, we're talking about the principle that was expounded in that case. What's the neighbour principle say? Can you talk about that?
Well, the neighbour principle, the neighbour in this, Lord Atkin describes the neighbour as a person so closely directed and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I'm directing my mind to the acts or omissions which are called into question. Yep. So basically, in layman's terms, anybody who's going to be affected by my acts. So if I'm bottling some beer, it's reasonably foreseeable that somebody who I don't know, who I may never see, might drink that beer. So they would be the neighbour.
So the neighbour's someone that you can foresee.
That's right.
Yeah, you can picture that something you do will affect you or you. It doesn't necessarily mean my neighbour as next door neighbours, correct?
That's right.
Yeah, it could be someone that's 30,000 miles away. Okay. The other thing that's interesting about this case, among other things, is the fact that for some reason, all traces of the case, people were trying to eliminate all traces of this particular case. Stevenson's factory no longer exists. It was demolished in 1960. The Wild Meadows Cafe was demolished in 1959. And Minigella, the fellow that sold the actual ginger beer, his house was demolished in 1959 when he died. Yep. Now, the thing is, all the other properties around these three houses, properties and also Stevenson's factory, still stand. So it's amazing how someone along the way just wanted to erase all traces of this case. But the thing is, it's there.
And a couple more twists. Mr. Stevenson died himself in 1932, just as the case was finishing, at the age of 69. That's an early death.
So it would have taken a heavy toll on him.
And unfortunately, Mrs. Donahue, she had a sad life. 3 of her children died soon after birth, and she herself died in a mental hospital in 1958, aged 59. So unusual twists.
Yeah. And Beth, the other thing is this. The other thing about this case that was fascinating was that I don't think anyone ever argued the facts.
That's right.
They turned on the law. I mean, in the first instance, when I got to the House of Lords, in the court downstairs, and, some of the key elements that I'm not sure if they were ever proven or ever anyone turned their mind to it, was there a snail in the bottle?
Yeah, some people say that the whole case was a hoax and there was actually no snail in the bottle. So.
Right, that's number one. 2, who did the bottle belong to?
That's also an issue. Did it have their brand on it, or was it a return bottle?
Yeah, because they used to return the bottles and get a refund.
Yep.
In the old days when we were growing up, same story. Right. You'd return bottles, you get your money back. And what about the third thing?
Well, no, just of interest on that.
Yeah.
We were having a conversation the other day with some of our learned friends, and a young solicitor said, "Oh, look, I've had a chat to my grandmother." Now, 1932 is not that long ago, so the grandmother's still alive. When she was a little girl, she used to play at the ginger beer factory, and they used to play with snails. Now, what does that add to this? Just another little yarn or another little story that may mean that the snail was in the bottle.
But Martin, what's to say that the ginger beer that was come out of that bottle was from Stevenson's factory?
Well, they didn't argue that. They went to that principle of law.
And I'll take it one step further. What's to say that she didn't get gastroenteritis from the ice cream?
That's right.
Because, let's be realistic. Ice cream. Who mixes beer with ice cream?
Yeah. No, a decomposed snail will do it for me.
That's a bit
anytime.
like, having orange juice and spaghetti sauce. Yeah. It's just insane.
Look, another issue which I found fascinating when...
I think you'd get a guttache out of that, wouldn't you? Yeah, guaranteed.
When talking about the case, Tony, was this lady was a pauper.
Yeah.
This case went all the way to the highest court in the land, with eminent counsel acting for her because they saw it as such a unique area of law to be finally decided. So they acted in the lower court, the next court, up to the House of Lords over a period of 4 years to get the decision.
Is that because they thought at some point in time, eventually, we're going to get a principle of law that picks up?
That's it.
And they were famous.
That's right. This is the famous case that started it.
That's it. Yeah, so. And also, just going on from that, Beth, there's been some interesting cases that evolved from that.
That's right. Well, Granton Australian Knitting Mills. That's the Australian adaptation of the Donahue and Stevenson principle, and that also has really interesting facts. Actually,
it does.
The facts of this case is the plaintiff bought some underwear, some long johns, I believe, and he put them on.
A bit like the stuff they used
he
to do in
didn't
the
wash
Westerns.
them. Yeah, he didn't wash them. He had them on for a week,
Oh.
and he got some dermatitis problems. He got a rash. So it was found that the company that manufactured the underwear didn't wash off the, I think it was sulfate,
Yeah, the chemical.
didn't wash off the chemicals. And they were found negligent in that respect because it was reasonably foreseeable that somebody would get a rash from not washing off the chemicals from the product.
Okay.
And also,
do you know what he
leaving them on
got?
for a
Do you
week,
know
I
what
would have
damages he got?
Not sure actually.
Well, I know that Donahue got £200 back then,
Yeah, that's
which sounds like a lot of money.
well, £200.
1932.
Yes,
And she died a pauper.
yes. £200 and 32. I haven't. They haven't given an update equation of what that was, but it's obviously a lot more money. It's a lot of money back then. It would be a lot more money now. And Grant, he was successful.
He was
At the
successful.
first court, he lost, but the Privy Council rectified it. Is that correct?
That's right. He was successful on 2 counts on the contract principle because he actually bought the material himself, unlike Donahue, and also the negligence principle as well.
What about, what do we know about the lawyer that took on the case for Mrs. Donahue? I mean, what's fascinating about him is he had a history of taking on cases. I think he could have been the one involved in those mice cases.
Okay.
And he'd lost those.
Oh, well, it
and he was
spurred him on.
pretty game, wasn't he? He was
Yes.
pretty game.
Look,
And
It's like the asbestos cases here in Australia. Go to another dimension. Those asbestos cases were first decided in Western Australia. They lost at the first
They
instance.
kept on losing.
That's right. Then when they brought it over to Victoria and they had a case in Victoria, they won.
and why didn't they want him to win in Western Australia, mate?
Well,
the
that's
judges, it was concocted.
Yeah, that's
Is that what you're saying?
Western Australia is where the asbestos was mined at Wittenoon. Yes.
So, and anyway, going back to what Beth was saying, we got Grant in the Australian Knit Mills case, then there was Rowlands and Fletcher where water was released from the neighbour's property and went into the other person's property and he sued for the damage to the place. And there's been a host of other cases since then.
Certainly.
And now we're at a point where you've gone from having to prove signs of fault to almost having to prove nothing but the fact that you're injured.
That's the
product liability.
Yeah, the Commonwealth of Australia, they have brought in what's called the Trade Practices Act. And as an extension of what starts back in 1932, they have now for faulty manufacture of goods, in other words, a good's not fit for the purpose for which it's designed, it's faulty, it's now trade practices and it's almost strict liability.
So the law's really, really evolved, hasn't it?
Yes, it has.
And also with airlines, you only have to show that there's an accident as opposed to who caused the injuries.
Yes.
So that's fascinating too. Anyway, look, I think we're getting close to an ad break again, and we're going to go off for our sponsors, and we'll be back soon with Viv's mailbag.
Thank you, Beth.
And thank you, the lovely Beth, for coming on board.
Thank you for
It's
having
been
me.
sensational. Thank you very much.